Hey, estate planning attorney Paul Rabalais here, and in this video we're going to talk about what you should look for when you're reviewing, prior to signing, when you're reviewing your estate planning document drafts. Okay, so it can be a real source of frustration, both to the lawyers who prepare these documents and their clients who those documents get prepared for. It can be a real source of frustration when it comes time to review the documents, make sure they say what they're supposed to say before, they get signed and made official. And really there's two different ways estate lawyers work with their clients once the lawyer has completed the preparation and customization of all the documents. Some lawyers will say, okay, Mr. and Mrs. Client, we're not going to send you the drafts. Just come on into the office. We'll quickly go over them and you can sign them and make them official. And then other lawyers will say, we're going to send you the drafts, and some clients actually request it. And so you see some lawyers, sending out the drafts, wanting the clients to review them. And then there's usually, a question and answer and a discussion session after that before those documents are made official. And I got to tell you, this is a difficult video to make because there's perspectives of lawyers and there's perspective of consumers or clients. So from the lawyer's perspective, I know that there are some lawyers who draft, I want to call it short documents. I'm going to get to what I mean by short and long in a little bit later in this video. But there are some lawyers who, they want to just cover the basics, and they want to cover reasonable contingencies, and they want to cover other matters that probably need to be addressed. And so their documents are relatively short. More on that later. And then there are lawyers who prepare very long documents. They want to cover, any possible contingency that might occur. And again, more on what makes longer documents long, a little bit more in this video. And then from a consumer's or a client's standpoint, lawyers will get some clients who will say, Mr. or Mrs. Lawyer, just give me a brief overview of what my documents say, and if that sounds good to me, I'm ready to sign. And then you're going to have other consumers or clients say, you know what, Mr. or Ms. Lawyer, I need to understand every word in my documents. My daddy once told me 40 years ago, never sign a document you don't understand. I want to go and re-examine every word, every comma, every period, every semicolon. Let's get to it. And that's when I kind of cringe when I hear that. But nonetheless, it just happens and it exists. So as you might imagine, as I get into it here with the different documents and what you should be looking for, there are certain things that, consumers call them boilerplate, that are in all of the documents. I prefer to more look at it as those provisions in the documents that I've spent 30 years of blood, sweat, and tears trying to formulate, tweak, revise based on experience, new law. And so there are some things that you'll find in just about every set of estate planning legal documents. So there's various kinds of legal documents that make up a typical estate planning program. I'm not going to address them all, but I'm going to address the will, the trust, the power of attorney, the living will, and what to look for. And I'm going to go start with the easiest and move on down the line. So the first one I'm going to talk about is the living will. That's your statement regarding your desires about life support machines. Most of those living wills are fairly standard. And I will also tell you that from here moving forward, some of this can be and is state specific. I'm an estate planning lawyer in Louisiana. Most of what I tell you is applicable wherever you are, but just know there may be some slight differences based on what state you're in. So in the living will scenario, that statement about life support machines, I know in kind of our standard form, people should take a look at some of those elections where they can initial certain places on their living will regarding, for example, whether they'd want nutrition and hydration withheld in the event that they're in that, profound comatose state with no chance of recovery, and the machines are serving only to artificially prolong the dying process. So I'd be taking a look at some of those places where you have the opportunity to make an election, like the one regarding nutrition and hydration. Okay, moving on to the healthcare power of attorney. What do you look for there? I'd say the first thing you look at when you're reviewing drafts is, who did you name as what I call your agent? Who did you name to be able to make your healthcare decisions in the future? And then not only look at that, but then see if there is an alternate agent listed. Most married couples, they appoint their spouse first, maybe an adult child as the alternate. And so I would be looking at those things first, and then you're likely to see certain provisions in your healthcare power of attorney that, you probably don't want to focus too much time on that. They're in some form in your healthcare power of attorney, there's going to be language about how you are giving your agent the authority to do things like consent to or refuse medical care, the ability to admit to or discharge from medical facilities. You're likely to see some language in the healthcare power of attorney about giving your agent access to your medical information and records, including information governed by the HIPAA Act. However that's written, that's kind of standard, and I wouldn't focus too much on the little commas and the ands and the ors in that language. And so then we move on to the financial power of attorney. Again, you're going to want to look at who's your agent, who's your alternate agent, and if you perhaps named two people as the alternate agent, you're going to want to look at the provisions of, or as your agent, you're going to want to look at the provisions of how they can act. Do they both have to act together to get things done, or can they act jointly or separately? And then in that financial or general power of attorney, you'll likely see, general powers that you're giving your agent. You may want to take a look at whether your financial or general power of attorney is effective immediately, or it's effective only upon your incapacity. And if that's the case, you may want to take a look at what triggers your incapacity, which triggers your agent's authority to act on your behalf. So that's something you might want to take a look at. But again, don't get too focused on these kind of typical standard provisions where you're giving your agent the authority to handle your, you'll see paragraphs on banking and financial transactions. You'll see paragraphs on giving your agent the authority to handle your real estate and other asset or property transactions. You'll see language in there about if you're giving your agent the authority to act if you're a participant in an estate, and your agent might need the authority to act on your behalf regarding estate matters on another estate, or litigation, or your tax matters. That's kind of common language in a general or financial power of attorney. You may want to take a peek at, while powers of attorney aren't typically revoked, occasionally life changes and people do want to change or revoke their financial or durable power of attorney. So you may want to look at what would be required if you wanted to revoke your power of attorney. And then in my state, what I'd be looking for, or what I do look for when someone presents a power of attorney to me, in my state of Louisiana, there are certain things that must be expressly stated in the power of attorney for the agent to have that power. Things like the power for the agent to make a donation of your assets on your behalf to others, the power to accept or renounce a probate or succession, and the ability to contract a loan on your behalf must be expressly provided for in that financial or general power of attorney. So those are the things you might want to expect to see in that scenario. Then let's move on to your will or your last will and testament. First, I'll mention some things that don't focus too much time on this. And so some of those longer wills are going to have paragraphs, sometimes pages, and in those paragraphs or in those pages, it references language like, I direct that if my estate, or if I owed any taxes at the time of my death, I direct that all those taxes be paid. You'll see another page of language that I direct that any debts that I have are paid at the time of my death. You know, all that stuff is required whether you have that in the will or not. So now I'm starting to touch on some of that stuff that makes wills long. That sometimes doesn't necessarily need to be in there, but what you do want to look for whenever someone brings a will to me, and I review wills often, particularly after somebody dies, the survivors bring the will to me to handle the probate matters. So I look at the executor paragraph, which is who's named as the executor, and then what I often don't look at initially is, again, there could be paragraphs or pages about all of the powers that the executor has as the executor. Now, I do want to look as to one specific power. I do want to see if in the executor designation they authorize this independent executorship, which is real important in Louisiana and in a few other states. So I will specifically look for that right out the box, right at the get-go. And then, of course, I'm going to look at the bequest, provisions, any kind of specific bequests when a person leaves their home or a certain amount of money. I want to look at those closely. I want to look at I'll call them residuary bequests, which every will has or should have. If there are some specific bequests, then there's going to be another provision that says, I leave the rest of my estate to this person or these people equally or these people in these percentages. So those are really important customized provisions that really are the first provisions that people tend to look at when they look at a draft of a will. And then really the last kind of typical estate planning document is a trust. So in the trust, you're going to want to look at who the beneficiaries of the trust are. There's going to be some paragraph that states the income beneficiaries of this trust are, and maybe another paragraph that says the principal beneficiaries of this trust are. Those are, again, customized provisions. You want to make sure you get all that just right. You're going to want to look at is this trust revocable or irrevocable? And so I'll link you to a video that talks about the kind of revocability versus irrevocability of trusts. You're going to want to look at the trustee provisions. So most trusts name a initial trustee, name a successor trustee or co-trustees, and sometimes even a third trustee or co-trustees, because sometimes these trusts are in effect for many, many years. Some of the stuff that makes, for example, an 80-page trust instead of a 4-page trust, I'll give you some examples. So there's usually provisions in a trust about trustee powers and trustee duties. So, trustees of trusts have certain powers to do certain things, when they're acting in their capacity as a trustee. And so some trusts are going to say, especially if they're done here in my state of Louisiana, they may say, this is the short trust. A trustee has all of the powers that a trustee may have as enumerated in the Louisiana Trust Code. And then other trusts, which may be 20 pages longer, will actually list out all of those powers that a trustee would have anyway as enumerated in the Trust Code, but some lawyers want to put, because there's 21 different paragraphs or provisions in our Trust Code, 21 different powers that are addressed in our trustee powers that are addressed in our Trust Code. And so a trust might say the trustee has the powers enumerated in our Trust Code, simple as that. Or a trust might say, here's all the powers that a trustee has, and then the trust lists out all those 21 powers. That goes on for many, many paragraphs and many, many pages. And really, those two trusts have the same effect. Same thing with the trustee duties. Trustees have certain duties to act responsibly. And so in every state's trust law or trust code, it lists what the trustee's duties are. So in the short trust, maybe there's just a few trustee duties listed, or maybe it says the trustee has the duties as enumerated in the trust code. And then the other trust, that's the 5-page trust. And then there's the 80-page trust that says the trustee shall have the following duties. And here in my state, there's 17 statutes on what trustee duties are. and sometimes they just kind of get copied and pasted into the trust instrument, which sometimes makes the review of the trust more difficult and more time, because the settlor of the trust, who wants to understand every word and every provision and every comma, gets hung up on some of that trustee duty and trustee power language that really may never come into play. So anyway, I tend to be, just for what it's worth, I tend to be in the camp that likes the shorter documents. Let's address what we need to address. Let's cover the reasonable contingencies, and then not have all of this kind of, I'm going to call it fluff, for lack of a better word. I think some lawyers think that the longer the documents are, the more they can charge. So, but sometimes, if I were to ask a client, do you prefer the short version that gets right to it, or do you prefer the long document that has, a lot of fluff? And what happens with the long document that has a lot of fluff, those clients who like to kind of understand everything, they'll say, Paul, let's turn to page 27 of this trust. On the first line in paragraph 17 of the trustee powers, does that comma really need to be there on the first line, or perhaps should that be a semicolon? And so, just you get some of that. And I understand consumers, these are important matters for consumers. They want to understand it. But so there's just that balance that both the lawyer and the client need to address when the lawyer's preparing things and the client is reviewing things. So like I said at the beginning, consumers can and do, clients can and do get frustrated sometimes when they attempt to review this estate planning documentation, but they don't fully, understand them in depth. So maybe this video helped you kind of get over that hump and realize what's important to look at and maybe what's less critical, so that you can focus on the matters in hand, make your informed decisions, feel comfortable with it, get it done, and move on, in life, knowing that you have the peace of mind that things are addressed the right way. Last two things I would look for is, if I were you right now, I would look for the like button. And I would turn that from gray to blue. That tells YouTube to show my videos to more people. If you haven't already hit the subscribe button and the notification bell, hit it right now. That way you won't miss anything. All right, I'm Paul Rabalais, estate planning attorney. Y'all have a great day. See you next time.